Good morning, all. Uh, in the last class, we are discussing about custom as a source of international law, and after that, we have completed and we have looked into one of the important case that was related to North Sea Continental Shelf case. We have, in that particular case, we have got an idea that how duration is not important when you look into a custom. The court, basically International Court of Justice, decided in this particular case. And the another thing which we found is that sometimes when you are signatory of some treaty, you have to ratify the treaty also, because where the proper intention of confirming or giving consent is by of ratifying the treaty. So this is also very much important while you we deal with this particular topic. That is, and another thing, that for customary international law, one thing is very much important. That is, the state practice would be there, and evidences of that state practice would be there. That means when you are trying to convey that there is a state practice and there was a state practice for last so many years, you have to provide evidences related to that, and which for which I have given that you how you can identify the evidences. You have to look into many different sources. For example, you have to look into the different meetings, discussions, whatever is present in this particular at the time of that particular state practice. You can look into that. It can be newspaper articles, it can be news of that time, whatever news was at that time. So these are basically evidences of a state practice. So in a way, we can say that what is state practice. I can say that we as a country, we are following this particular thing with a particular country. This is an state practice. But when you have to look into this particular state practice, how you can identify? By looking into the evidences of that state practice. In a way, how what thing we have to look? That means it can be discussions between two government officials. It can be discussion in the parliament regarding that law. So these all things give evidences about the state practice. But it is not just like that you say that this, we have a state practice, that will not suffice the total, we can say, guarantee that there was a state practice. There are chances that people will look into, or the officials will look into the documents, and then they will identify whether, or when the matter comes to the International Court of Justice, the International Court of Justice will look into this particular matter, and they will try to dig out all the whatever evidences are present for the state practice. So that is also very much important. And not only state practice will basically suffice all the problem, there is a need of opinio juris also. That means without opinio juris, you can't say the it is a customary international law. So for customary international law, we need state practice as well as opinio juris. So this is one of the important things which we have tried to be uh, complete, or basically we have tried to get an idea about that how the custom is very much important. So have you understand the concept? Have you understand the case? North Sea Continental Shelf case, you have understood? You have any confusion regarding that case? Because that case is very much important. If you have any confusion, you can ask me right now only. Otherwise, I will move to next topic. Everyone is satisfied with whatever we have discussed in the North Sea Continental Shelf case? Everybody's mic is not working or like that. What is the problem? Nobody is talking, or are you sleeping? Are you traveling? What is the main reason that nobody is saying anything? Ruchi's mic is not working. It's okay. She has also said in another classes also. What about others? Varun, Smriti, Osika, Amrit Raj. Yours mic is also not working.
Yes, sir.
It's working, so you can reply. Otherwise, what will happen? It is, and monotonous will be the situation of the class will be. Make this class interactive. I'm not saying that in every topic you ask question, but at least some inquisitive mind should be there. Otherwise, what will happen? I will just teach, and you will just mug up all the things, and you will write in the exam, and I will give numbers to that. So that is not the this class is not about that only. We can make it interactive also on virtual platform also. It is not like the only physical classes will be uh, interactive session will be in physical classes. So we have till now we have completed the custom as a source of law, and I have discussed many cases in that. That was asylum case was there, right to passage case was there, Scotia case was there, Lotus case was there, North Sea Continental Shelf case was there. North Sea Continental Shelf was one of the important cases where, so I have discussed that in deep manner. Now we will move to the next topic, and that is treaty. Now, what is treaty? We can say treaty is more of a modified form of custom, in a more modified as well as codified. We can use the word modified and codified. So how we are basically how this is important, because in custom we generally have consent in implied manner. That means if you are saying that this is a custom and every country is following this custom, so some country can say that this is an implied custom, but not in the case of treaty, because a treaty is codified, treaty is well defined, treaty is made with lots of discussion, and by preserving the essence of that custom. So this is very much important as an current scenario. When I am saying that custom is an oldest source of law, it can be by for international law or domestic law. In the same sense, when I am saying treaty, treaty is one of the most important at the present time as one of the important source of international law. So for when I'm saying treaty obviously it is more important, but the origin of that particular treaty in most of the time is from custom. So custom is also important till today, and it is not like that the custom is not important till right now. Custom is important right now, but when you basically take this into consideration, that what will be more perfect for right now, then you have to say that treaty is most important source of international law at present. When you look into the article 31A of the statute of international court of justice, which lays down that court while deciding any dispute shall apply international convention. That means when you look into the 38(1)(a), and after that it is 31(8), that particular B, that means there is first is international treaties are there, customs are there. So when you look into this particular topic, you will find that the establishing state, or they have basically what the benefit of this treaty is, that because the treaty is expressly adopted or recognized by the contesting states. That means if I am saying that, I'm just giving an example of that. Uh, right now, there was a dispute in International Court of Justice that was regarding the Kulbhushan Jadhav case. Now, what happened this in this particular case? In this particular case, the Pakistan court had have given, somebody's mic is on. Please switch off your mic. So in this particular case, what happened? Without giving consular access to this Kulbhushan Jadhav, he was given a trial in Pakistan, and all the trial till Supreme Court, he was given a capital punishment in this particular trial. And now, when this particular matter comes to that, because Kulbhushan Jadhav is an Indian citizen, so India took this particular matter to the International Court of Justice, and what they have tried to convey that the consular access should be given to that particular person, because we have in the same if you look into the this 2611 the Bombay attack, you find that we have provided consular access to this Kasab and all the people. So in the same way we are saying, because Kasab was one of the person who was arrested alive, so that we can say that in this particular matter we can say that we have given consular access. In the same way, India demanded that there should be consular access given to them. Now what is how they can conclude this, because there was a custom like that before also, that and it is also on the basis of natural justice. So treaty is important, and why Pakistan also contested that matter in International Court of Justice, why they have reached there for argument, why they have sent their advocates there. So the reason was that because Pakistan also recognized that treaty, India also recognized that treaty. So on that basis Pakistan have to defend themselves, and it is whether they have lost or whether they have win that particular that case, that is a different thing, because India have already have won this case, and the International Court of Justice has directed Pakistan to provide consular access to Kulbhushan Jadhav. So this was in basically in condition where you can say that when any dispute occur, and both state is accepting that particular treaty, so that make the decision more convenience. That means people will start, the International Court of Justice have less work to do, because both parties are accepting that particular treaty or agreement. They are following that and they are accepting that particular treaty, so it makes their work easy. Because if there is a dispute which they have not satisfied, or they are not accepting the treaty, that will make another dispute, another issue out of that. So first of all, the both parties are accepting the treaty. This is first thing, and after that we can dispute on the other matters or articles related to that treaty in this particular treaty. So this was, and basically when you accept the treaty, you are signing that treaty, you are ratifying that treaty. That means what happened, you are giving an express consent. It is not implied consent, it is an express consent. So when you are giving something in express way, but that means by giving something by way of not doing, or by giving some documents related to that, you are signing that document, ratifying that document. So on that basis, for example, right now I say that I will promise all of you that I will give good marks in exam. So this is a promise. So it is an, and this I have said in an express term. But what I have done, what I have instead of saying this in express term, I have said that whoever will write good give good. So on that basis, on that basis, you can't say that the particular setup is in a way, we can say this particular setup is in a way that express things are given more priority. Always you will give the same priority to the express term, and you will give less priority to the implied term. I think this is an okay for all of you, that everything that is an express, and I think most of you are clear with the term express and implied. Are you clear with the term, Varun? What is express and what is implied? Varun, or anyone who is active right now, who is present in this class, I think anyone can give answer to that. This.
सर एक्सप्रेस का मतलब कि जैसे कोई कुछ बोल करके बताए, और इम्प्लाइड का मतलब जो समझ सके, मतलब उस चीज को
By their
बिना
action,
कुछ
that means by their action. For example, you are coming to, like, from our next week you will come to Galgotia University, and by you have to go to Parichok, you will directly sit in the auto, and because the most of the autos are for Parichok. Now what will happen, that particular auto will take you to the Parichok, and what will happen, you are not saying anything, and you have paid 30 rupees to that person. So this is an implied way. But another way, that you will go to that particular driver of the auto, and you will say that I want to go to Parichok, what fare I have to give. So this is an express term. So this is quite easy. I think you have studied in contract also. So I am just giving some idea, that I know most of you are knowing that this is just an express way of teaching, that I have to give some reminders or some details of the past classes also, which you have studied in different subject, because it is related to this. Now when you look into this particular treaty, now what is treaty? Now anybody will ask that what is treaty. You have to look into that. The treaties are agreements between two or more states, or between other subjects of international law, by which they create or intend to create a relationship between themselves. That means what is this particular treaty is nothing but an agreement. It is we can say agreement in domestic term we use, and treaty is an international term we use in international law. So treaty is between two, is an agreement between two or more states, and it can be between two international organizations also. It can be between two states also. It can be between states and international organization also. So in a way we can say that treaty is basically an agreement in a simple term, and that can be between two states, between more than two states. It can be, now one example of multilateral treaty is WTO, GATT, These are the multilateral treaties. Bilateral treaties can be there. Bilateral treaties can be, for example, there are many bilateral treaties between India and Bangladesh. There are bilateral treaties between India and Sri Lanka. There are bilateral treaties between India and Nepal, Bhutan, Bangladesh, Pakistan. These all, even Afghanistan also before the acquisition of Taliban. These all are basically example of bilateral treaty. Bi, that means two, lateral means between two, agreement. Bilateral means between two people, that is an agreement. So bilateral is also there, and there can be multilateral also, and sometimes we use plurilateral also. Now what is plurilateral? Where more than two and less than, we can say, 10 or 12, so that can be a plurilateral. That is in plural term only. So it can be 8, 9, 10. For example, SARC agreement. So SARC agreement is an plurilateral agreement. Is in, we can't say that is in multilateral. We can also use multilateral, but the more perfect word will be plurilateral term. So that is also important in sense of this particular topic. That is an agreement, and that particular agreement in relation to, and this particular, 1 minute. Okay. So this particular agreement, which is between two or more states and or between subjects of international law. That means what are subjects of international law? Anyone? Nancy, what are subjects of international law? You can write in the chat box also. It is not like that you have to unmute your mic to say something. Shreyans, what are subjects of international law? Shreyans, Smriti, what are subjects of international law? What are subjects of international law? Ah. Amrit has written that it is states, international organization, or non-state actors. Sometimes we say NGOs are also sometimes recognized. Some international NGOs like Amnesty International is there. So these NGOs are given, and we can say given in status of an international, or we can say subjects of international law. So these were the important points which say that whenever an agreement, it can be between states, it can be between international organization also. So on that basis we can identify that these are treaties and these are important. If it is between this particular agreement is between two states, that is important. If it is between some NGOs, and that in NGOs are not so recognized, so we can't say that that particular treaty is important in nature. So it depends totally on that particular situation. Now, right now, many customary laws are converted into treaties. So why the reason is to converting those things? The reason is that to giving more support to this particular customary laws, and by doing that, what will happen, if you recognize those treaties, many states become participant of that particular convention or treaty. So it gives a particular of a general treaty type of situation they give, and general express situation they give. So in a way we can say that that particular signing of any treaty or converting a treaty custom into treaty, it give more recognition to that particular convention, or that particular convention, or we can say the particular custom. So there are many chances where a customary international law is converted into conventional law, that is in the form of treaty. And because the consent is express, and in customary law the consent is in implied form. For example, there are example, Vienna Convention on Diplomatic Relation of 1961, it was converted by customary law. Vienna Convention on the Consular Relation of 1963, these are examples of laws which were converted into from conventions to treaty. One of the very good example is law of the sea, United Nations Convention on Law of the Sea of 1982, and before, even some conventions before that also, all are based on, most of the law of the sea, we can say in a way, is based on customary law. So what we have done, we have converted those customary laws into treaty to so that more and more people, more and more state participate in this convention, and in a way they become party to, and they try to make an uniform system of law on this particular subject, whether it is sea, whether it is space, or any place. But what we want to do basically, the process is to turn customary law into a treaty, so that more express assurance will come and more party will come, because the interpretation will be more easy as compared to custom. Because in for custom, what we have to look into that, for making that custom to apply as a customary law, we have to look into the state practice, we have to look into the opinio juris, and we have to look into the evidences of state practice also. So in a way, when you make this thing as a treaty, that particular the solution is that you don't have to look into state practice, you don't have to look into opinio juris, because it is already in express term, and XYZ country has already ratified this. So in a way, we can say that this treaty is more easy to understand, more easy to give assurance, more easy to accept, and more easy to apply also. So treaty is so much important in the present scenario. Custom was important, custom is important, but treaty is right now, the treaty is most important right now. Okay. Now there are two types of treaties also. Now the two types of treaties, that means in a way we can say by member of countries, we can say there can be three types of treaties: bilateral, multilateral, and it can be a plurilateral also. But by way of what is the work of that particular treaty, on that basis we define there are two types of treaty. The first treaty is general treaty, and the another is particular treaty. Now what are general treaties? General treaties are those wherein most of the states of the world community are parties, and which are open to accession by other. That means it already, that particular treaty is accepted, and by way of this particular treaty acceptance, most country are open to that. Even though right now they want to become party of that treaty, they can become party, and most of the countries in the world is already the is party of this particular treaty. Now the another thing is that they, this particular treaty, it crystallize very important rules of universal community into international law. That means they have accepted those rules into international law, which are binding on all the members of the state of the world community, be they parties to them or not. It is so because they reflect customary international law. Now what are general treaties? General treaties are basically reflection of customary international law, and these laws are accept, whether you are party to that treaty or not, you have to follow that. Because if you are party to a treaty, you have to follow this through treaty. But if you are not party to the treaty, by way of customary international law, you have to follow that. Because there are some laws which there are customary laws which are acceptable by every state, whether you are party to that or whether you are not party to that. So on that case, the general treaties are those treaties which are have universal acceptance, and that particular treaty has converted into a new form of treaty, in a form of treaty, and you have to follow that treaty even though you are not party to that. Now you will ask, sir, why they have to follow this if they are they have not party to that? They have no, they don't have to follow on the basis of treaty, but they have to follow that thing on the basis of customary law, because it is already an existence customary law. So even though you are not party to that, you have to follow that, because this is a customary international law. So you have to accept customary international law even though you are not party to that. But if you are party to the treaty, you have to follow, because this is an express term. So what are the example of this particular types of treaties? What are the general treaties? The general treaties are Hague Convention of 1899 and 1907, Geneva Protocol of 1925, General Treaties for the Renunciation of War of 1928, and Geneva Convention of 1949. Now, what are these treaties? These treaties are basically based of international humanitarian law. Now, all you know about what is humanitarian law? Have you have idea that about what is human rights and what is humanitarian law? Anyone? Do you have any idea what is difference between human rights and humanitarian law? The human rights is basically where when there is peace, the human rights is applicable, but during war, the humanitarian law is applicable. Human rights is also applicable, but humanitarian law is more applicable, and it is basically a law of war. And on that particular basis, they decide things, different things, what to do in war. So humanitarian law is the differences between these two. So the basis of the humanitarian law is Hague Convention of 1899 and 1907. So by following this law, it was before that there was customs regarding law, there was customary rules regarding law, that how to fight war and these things, and these customary laws were converted into treaty in two Hague Convention, that was of 1899 and 1907. So these laws give basis to that how to fight war and how to uh, uh, basically participate in war. What are the rights and duties of any country if they are aggressor country, or if the particular country is defending country? So what are the rights and duties? So these laws basically give, and or these treaties basically provide an express term of international humanitarian law, that is of Hague Convention of 1899 and 1907. These are general treaties, because even though these treaties you are not ratified the treaty, you have not become signatory of this treaty, you have to follow these things in a way, by way of customary law, not as in treaty but as in customary law you have to follow. So these are example of, we can say, of general type of treaty. So in a way we can say that this is a general treaty. Now the other, another type of treaty is particular treaty. Now what is particular treaty? The particular treaties are generally referred to as bilateral treaties or plurilateral treaties or ordinary treaties, wherein number of parties is two, more than two, or that can be any number also, that means multilateral also. They also known as contractual type of treaties or treaty contract. The another name of this particular treaty, that it can be treaty contract also. That means in where there are bilateral parties are there, and in a way there are more than two parties are there, plurilateral treaty is there, and these are basically treaty contracts. So these type of treaties are basically created for two or more states, and they have been distinguished from lawmaking treaties which create law for most of the state. That means now when I'm saying general treaty, for example, what are the example of general treaty? Even the 1899 and 1907 Hague Convention is there. The general treaty can, another treaty can be the uh, United Nations. It is also formed by a treaty. The GATE, the WTO, these are examples of that a universal law making system. For example, when I'm saying trade, you have to look into WTO, World Trade Organization. When I'm saying WIPO, that means World Intellectual Property Organization, you have to, that this is related to IPR, and they are making rules on IPR, international rules. When I'm saying WHO is one of the organ of International Coast of United Nations, but that particular, what they do, they have to look into matters related to health. So in a way, general treaties are law-making treaties, and particular treaties are treaty contracts. That means it is related between two states. It can be bilateral treaty, it can be plurilateral treaty. So these are not law-making treaties. In a way, there can be example of law-making treaties also. For example, if you take the SAARC, that particular between 8 countries, which is a regional organization. So in a way, we can say that that also participate in creating law, but it is related to only laws which can be acceptable in the Indian subcontinent or between the SAARC nation. So in a way, we can say that there are examples of general treaties which is of regional nature also. ASEAN is there, SAARC is there. So these are example of that type of treaties also. So now there are many rules of extradition are evolved through this particular bilateral treaty. That means these there can be example of extradition treaties. Know what is extradition? You all know what is extradition. Extradition is basically when somebody has done some crime in this particular, for example, in India, and they have run away from India to different country, and we are trying to bring that person to. For example, there is Nirav Modi, Mehul Choksi, this Vijay Mallya. So these are basically people we are trying to extradite from outside. So extradition is there. We have extradited Abu Salem from Portugal. So these are example of extradition. So extradition treaties are always, most of the time, are bilateral treaties because it is between two nations only. So one nation from where the person has moved, outside or run away from their particular country, and he is moving and he's settled in different country. So it isn't bilateral. So most of the extradition treaties are basically example of bilateral treaties, or we can say in a way it is an example of particular treaty. So these are examples of in a way we can say these are examples of particular treaties where there are two contracting parties are there, or two sometimes more than two also. So this is basically an idea about the types of treaty. The general treaty, that means law making treaty, and another type of treaty, that is treaty contract, which is between two states only. Now when you look into the custom and treaties, that means how to identify or how they are legally binding. In the custom and treaties are two methods for the creation of legally binding rules. That means one way we can say these are basically faces of one coin. That means one side there is custom and other side it is treaty, and that particular coin is created to create legal obligation. You can create legal obligation by through custom also, and you can create legal obligation by through treaty also. So two faces of a same coin, we can say. It in the both method, the consent is very much important. That means consent of a state should be reflected, and they do not impose the obligation on those states which have not wished to bound by them. That means it is quite clear that if you have given consent for that, you have to follow that, and if you are ignoring that, on the basis you can also ignore that particular consent. So first of all, firstly, while in customary rules of international law, consent of the state is implied in nature, and the international convention, when you want to differentiate between custom and treaty, the first difference you can create is that in custom, the consent is in implied form. That means you are giving consent in implied form. That means you are not expressing that, you are implying by doing some action. And in what happened in the conventional laws or the conventional laws of, that means the treaty, we have giving the consent in express form by signing that treaty, by participating in that discussion, and after that signing the treaty and ratifying the treaty. So these are examples of that we have given in express term. Now the second stage where we are saying that how the custom is basically formed, the transformation of usage to custom takes fairly a long time. That means when you are saying that something is going on, some country is following some usages, that means they are following a type of pattern every year, the same pattern. So that particular custom takes more time to establish as a custom, because it is not right, because their need, what is the need of custom? It should be continuous, it should be certain, it should be not against the moral values of that particular state, it should not be against laws of that state. So it takes time to convince all the people or all the citizens or all the states which are participating in that custom. So custom take more time to establish, and it customary, the process is very slow in nature. But when you look into the treaty making process, it is more rapid. Sir, can a treaty violate international law? That means what you want to basically say, Mevas, you has basically have asked this question. So treaty, because you are saying like that something which has the origin from the same thing, how that thing can violate this particular thing. So in a way we can say that treaty, there are something which is very much important. There is a standard for that, that is peremptory norms or just cogence principle is there. So you can't violate those principles, but in a way treaty can sometimes violate, because it depends the treaty is between multilateral or whether the treaty is bilateral. For example, if two countries which are against international law, they can create a treaty, bilateral treaty, and that treaty can the content of the treaty can be violation of international law. So it can be possible, but that it only depends on the how that treaty is basically evolved and who are the members of the treaty. So by that we can say that treaty can violate, but it depends on the parties. Because for example, I'm just giving an example that today India and Pakistan basically signed an agreement or a bilateral treaty on that they will support slavery. That means the people who basically bonded laborers, for example. So this is against peremptory norm and just cogence principle. This is basically against the basic human rights. You can't put any person in bonded labor. You can't say that this person is my slave. So in that way, you can't say, because this is in peremptory law, you peremptory norm which you can't degrade. That means a standard which you have to maintain in international law. So peremptory norm is very much important. You can't degrade that. So any treaty which is degrading that law is violation of international law. So this is in relation to your question. I think I have answered your question. You need more explanation, I can also explain. You can text me, or you can give in this particular chat box you if you want more clarification. Is it okay, or okay, you are satisfied with my answer right now? So these are examples of that treaty can, but it depends on the parties also and the content of this particular what treaty they are making. So if they are making anything which is against international, for example, you are saying something that you are making law and you are not respecting constitution, is it possible? Yeah, what the process of for that particular, the article 13 is there in constitution which will review that law, and if the law is against the fundamental right, they will basically, what will they will throw that law outside. So in the same way, if something is in international law also, something that is against the international law, what will happen to those law, they will basically throw this particular law outside. The system will be different, because in domestic law it is quite easy to create and throw the laws outside, but for international law that will be a difficult task, and that's why the process of making law is difficult. By custom it is difficult, and by treaty it is easy, that is rapid in nature. But when I'm saying rapid, it doesn't mean that you will make any law. The rapid only signifies that how quickly you make law. It is not about how badly you make law. So that is also very much important. When I'm comparing custom with treaty, the process of making law in custom is slow, and the making of law in treaty is more rapid. But that rapid thing is based on the custom only itself. Most of the time we basically accept custom as in treaty, which I have given different example, whether it is law of the sea or whether any law you put, you will find some essence of custom in that. Because when the International Law Commission is working on particular topic, they will look into that whether we have customs related to that or not, or whether states are following that custom or not. So we will look into that only. So it take time. In some case it is more quickly, and in custom it take more time. So process is rapid, and in a way we can say that if we cannot precisely we say that particular time the customary rule has been found. Sir, you mean treaty can make law? Yeah, treaty is law. It is not like treaty is law. It is not like that. Treaty is itself a law. Treaty is like codification of international law. Treaty is in a way we say what is treaty. Treaty is basically agreements, and it is more codified, because you don't write treaties like in para. You give codification. This is article 1, this is article 2, this is article 3, this is, you look into the UN charter, you will find that is also a type of treaty. You look into WTO agreement, Marrakesh agreement, that is also a treaty, that is multilateral treaty, that is law making treaty, because they are making law. And when I am saying particular treaty, that is related to between two countries. So on that particular, I can give an example on that also. Particular treaty example is extradition treaty between countries. The another example is bilateral investment treaties, BITs, bilateral investment treaties. That means what happen in these treaties, they have the law related to how to invest in this particular country. It is applicable to both countries. India can invest in Britain, Britain can invest in India. So it is a bilateral investment treaty. India can invest in Sri Lanka, Sri Lanka can invest in India, and the rules regarding that can be that is put in this particular treaty. So particular treaties are examples are these treaties also, that where treaties are between two countries, it can be related to anything. Because if international law is not it is not basically blocking you to make bilateral treaties. It is saying that you can make regional agreements, you can make bilateral treaties, you can make, but whatever your things you are making, it should not be against the peremptory norm and just cogence principle. You can't make laws anything which is against human right. You can't make laws something which is against the basic features of human rights. So on that basis, for example, if you are making law, you are saying that I am respecting all the agreements of WTO, and you are making laws that the rules against that particular WTO rules. So that thing you can't do. It is in Indian law also, it is in international law also. So in a term we can say that when you have to look into the uh, uh, in the details you have to find out that what are the particular time the customary rule has been found. You can't say that. That means you can't give the essence or time when this particular customary rule has become a not norm. You can't say that because it is difficult. But for treaty, you can easily identify that when a treaty has formulated and date of with effect from this date, this particular treaty has come into force. For example, when I'm saying UN Charter, all you know that when the UN Charter come into force. UN Charter, when UN was created, on which date? Anyone? Ruth, when UN was created, on which date and which year? Saswat, on which date and which year the United Nations was created? Mewas, it is wrong answer. United Nations 24th October. Yes, right. Amrit, you are right. Another two answers are wrong. Not, it is not June. It is 24th October. And it is not 1995. It is important for WTO. It was 1st January 1995 when the WTO was established, and it was formed by General Agreements of Tariffs and Trade. They have converted that is also right now available. That is a multilateral agreement, and they have created WTO. It was in 1995 WTO was created. So you have to have idea about that. These are important international organization. It is these are basically basic questions which they ask in. These are the basic questions they ask in competitive examination. Sometimes I'm not saying that now the standard has evolved. Now they are not asking for date. They look into different things. But during my time or during when I was giving exams, they have generally asked this type of question because you can easily, if you have idea about the date, you can easily give or you can get 1 marks or 2 marks for that. For example, VDHR was adopted on which date? Universal Declaration of Human Rights. I have discussed in the class. Universal Declaration of Human Rights. On which date it was adopted? When we celebrate International Human Rights Day. It is 10th of December 1948. So these are the examples which you have to basically have idea about, because these are, if you are studying international law and if you have no idea about when the UN was created, that means you are not studying international law. You are just time passing on that particular subject. So because UN is very much important, when I'm saying international law, I don't have to say that what is the importance of UN. UN is most important body of international law. Due to that, we still have some chances of that there is peace and security. Otherwise, there are many instances where UN is not able to work on that particular topic, or WHO is not able to work on that topic. But there are instances where most of the time they have tried to avoid these things. So there are situations. So I will not comment on this particular topic because it will basically, it is not related to the critic. I can't do right now, because when we will able to complete whole syllabus, we can have a class on critic, so that I can take your all criticism of international law, and I will able to rebut all this criticism by way of my thoughts on the international law. So we are basically looking into that, and you will also look into that there are many chances where you are looking into the customary law, but that customary law is not adequate, or whether that customary law is not precise in nature. But when you look into the treaty, you will find that most of the time treaties are more clear and treaties are precise in nature. When I'm saying the treaty formation is rapid in a term, I always try to it is my basically view that it doesn't mean something is rapid in nature. It doesn't mean that you will make errors in that particular rapidness. You have to be more alert. International Law Commission works on particular topic for 4 or 5 years. When I'm saying rapid in international law means at least 4 or 5 years. It doesn't mean because the International Law Commission peoples who are basically part of that particular International Law Commission, these people are for 5 years. They basically participate for 5 years in this particular. So in a way, we can say that these topics or these things related to are rapid in nature. The term rapid as compared to the process of making customary law. we are comparing something, we are saying that custom is important or custom a treaty is important. So in the way when you are comparing, treaty is more fast, but it is not like that treaty I will make today one treaty. It is not like that. I will make some law. It is not possible because it need discussion, it need participation, it need people who are against that law also, because criticism is very much important for anything, even for teaching also. If you are looking into something and which I can't provide, you can criticize me. It can be by way of message, it can be by call, it can be by of writing through to me or someone else, that this teacher is not able to convince us on this particular topic. So criticism is very much important. So when I am saying rapidness, it doesn't mean that it will make tomorrow, I will make law tomorrow. It means when we compare something with, for example, when I am comparing the the duration of making law in customary law, in that, in a way, in that ratio, I can say that treaty is more rapid in nature. But rapid doesn't mean that errors will be there. So custom is, the problem with the custom is because it is not in written form, and sometimes it is not more precise and adequate. Sometimes custom is, some parts are missing, so that can be an example. And the another thing is of that related to that is, treaty is more precise in nature, treaty is more clear in nature. So in a way, because that's why we are giving preference to treaty. It is not like that we are giving preference, we are giving preference to custom, but we are trying to what, whom you will give preference, that is more clear, that is more adequate, that is quick in nature and without error. So these are the examples, these are the features of treaty. These are the express term. These are the example of the, when I'm saying the features of treaty, you have to write something, what is the important characteristic of a treaty, that how you can say the treaty is best of uh, source of law of international law at present. So now you will write that it is express term, it is rapid in nature, it is adequate, it is clear enough, there is less need of interpretation, there is less, if you are accepting treaty, there are chances of less conflict. So these are the example. Even layman who is not able to understand that particular custom will able to understand treaty by, if that person is knowing English in good manner, if that person is able to interpret something. So these are the examples of the feature or good characteristic of a treaty. Now the another question is that whether, if there is a customary international law, and on a following topic, in some topic there is a customary international law, and after that a treaty was made on that particular topic, whether the customary international law will cease to exist, whether customary law will end on that day. Is it, anybody can answer? There is a customary law, and after that there is a treaty on that particular customary law, whether that customary law will end on that day. For example, there is custom of Sat Fera, you all know, that is in Hindu marriage, there is a concept of Sat Feras, that is there, and there is law regarding that, the essential, that is in section 5 of Hindu Marriage Act, that is related, that what is the requirement. So that in that particular thing, the section 5, they have written that Sat Feras are required, Satpati marriage system. So that Satpati marriage system, whether after enacting that particular law, that custom has existed or that custom has gone? No, the customary international law or the custom, it's right, it will not, even though you have created some law on that, the custom will still be part of that. For example, there is a case, very much famous case of Nicaragua case. It is the case is basically between military and paramilitary activities, it was case. And this case, the International Court of Justice has basically quoted principles such as those, the non-use of force, non-intervention, respect for the independence, territorial integrity of a state, and the freedom of navigation continue to be binding as part of customary international law, despite the operation of provision of conventional law in which they have been incorporated. That means in the Nicaragua case, the court, in the International Court of Justice, has said that even the topics related to non-intervention, that means it is one of the important essential rule of international law, that you will not intervene in the domestic affairs of any country. It is about independence and territorial integrity. That means you will not aggress any country until another, otherwise that country has basically have war on you. So these are the example of customary international law. Even though you have accepted those law in your own treaty, international law has accepted those in a treaty, even though that custom will still exist. That means that custom will be there. It will not like that it will cease to exist. It is, the custom will exist. Even in this particular Nicaragua case, the International Court of Justice has said that even though you are party to, you have accepted that as a treaty in express term, it is not like that the whatever things are there which was in implied term, that taken more time to form. You have to, the custom will be there. That means customary international law will survive even after the making of something, some treaty on that particular topic. So these are the examples we can basically give while discussing custom and treaty. I will also uh, the the very much important thing is that the there was a case where we can say the court, in a case where the court had concluded in the North Sea Continental Shelf case and in the Nicaragua case also, the court concluded that customary law continue to exist and apply separately for international treaty law, even where two categories of law have been identical content. That means there can be chances where the laws are in identical terms, treaty have the same term, and the customary laws. For example, if you take the example of law of sea, United Nations Convention of Law of Sea is there, but it is not like that the custom on which that particular convention of law was established, it will cease to exist. It will also exist, and the other law, the same law will also exist. So this is an example. That means custom will survive also even after creation of some treaty on that particular subject and on that particular topic. So this is for this class. You have any question, you can ask me. There is 3 minutes. I can also extend 5 or 10 minutes, no problem. If you have any query, you can ask me. Nobody's any question? For any students, you have any query?